Welcome all to our webinar today, part of The Box, where we will be speaking about conflicts of interest for insurance brokers. My name is Neil Frankland and I'm a partner in our insurance disputes team, and I'm going to be speaking today with my colleague Andrea Stanford, a senior associate in the team. And whilst the session is being recorded and you can see us, we cannot see you. There'll be a question and answer session at the conclusion of the presentation, so please do feel free to post any questions you have during the chat, on the chat during the session, and they'll then be presented to us at the end by our colleague Harriet Strevens, who is a solicitor and our insurance professional support lawyer. And whilst we possibly cannot answer all questions by in the time available today, please, if you would like us to respond by email to a question at a later date, please just provide your email details and we can contact you from there. So let's start with the basic underlying principle that the broker is the policyholder's agent and represents its interests. As its agent, the broker owes the policyholder a duty to exercise reasonable skill and care in the performance of whatever instructions he's accepted. Now, that duty of care arises out of the contract, normally as provided by the TOBA, but also out of tort, because a broker is a professional and they've assumed a responsibility and a duty towards their clients, and also because of the imposition of certain equitable or trustee duties, known as fiduciary obligations. And those are really quite important for the purpose of managing and looking at the question we're talking about today in terms of conflicts, because they introduce a very strict regime and a very, very rigid regime in terms of how the courts look at the management of conflicts, and indeed the remedies for having acted in breach of a fiduciary obligation or breach of conflict in a conflict situation can be seen as being quite onerous. The extent of the broker's duties, however, is going to depend upon the circumstances of each case. But the unifying principle is that a broker must not, knowingly or otherwise, prefer its interest to those of its clients. So what happens when a conflict of interest arises between a broker and a policyholder? For example, when the insurer takes a point, declines a claim, avoids a policy for a reason that could be the broker's fault. Well, the policyholder will suffer the consequences of any error or wrongdoing by the broker, which would render them unable to recover under the insurance policy. Now, such situations have got the potential to undermine the broker's impartiality because of a clash that arises between their own interests and their express or indeed the implied professional, moral or contractual duties that they owe to the policyholder. Plainly, if nothing else, a breach of these duties could lead to a negligence claim against the broker by the policyholder, and from there a conflict arises. So as a starting point, where do we find these legal and regulatory considerations? So in addition to the common law duty of acting with reasonable skill and care, the unwritten rules of the tortious duty, brokers must conduct themselves in accordance with the FCA Handbook, which is produced, as I'm sure many of you know, under the Financial Services and Markets Act 2000, and the Insurance Conduct of Business Sourcebook, the ICOBs. Now, the FCA is clear about the importance of the management of conflicts by making the management of conflicts expressly one of their 11 individual principles of business for regulated firms. Specifically, Principle 8, firms must manage conflicts of interest fairly, both between itself, its customers, and between a customer and another client. And this links strongly back to Principle 6, which requires authorised firms to pay due regard to the interests of its customers and to treat them fairly. Section 10 of the FCA Handbook also sets out the requirements for firms providing a service to clients for identifying, recording, managing and disclosing actual or potential conflicts. It says that firms must take all appropriate steps to identify and to prevent or manage conflicts of interest. And this includes maintaining and operating effective organisational and administrative arrangements to prevent conflicts of interest. So, as ever though, perhaps with the ICOPs, the FCA rules and the rules themselves leaves it up to the firms to decide what organisational and administrative arrangements to put in place. And firms need to establish and maintain systems and controls that are appropriate to their business size and the activities that they undertake. There isn't an actual prescriptive list of what you must or mustn't do. It's down to you as an individual firm. But what you must do is you must demonstrate that you've taken all reasonable steps to prevent conflicts of interest arising. Now, for those of you that are Lloyd's brokers, I'm afraid there's an additional layer of rules, which mirrors in many ways the ICOBs and the rules I've mentioned. But that's through the Lloyd's Codes of Practice. And they, in addition, govern how Lloyd's brokers and the relationships between MGAs and cover holders also arise. And there are an additional layer of the rules that you need to comply with. It's worth perhaps giving some solace, though, however, that brokers are, of course, not the only profession here. They're not alone in the difficulties that they face. All professionals have a duty to avoid conflict. However, perhaps given the relationship that also exists between the insurer and the broker, is perhaps brought more slightly into focus in your sector. So what are some practical steps to avoid a conflict of interest? Well, as in most things in life, prevention is always better than cure. And there are some practical steps you can take to avoid conflicts of interest arising and to manage a situation when they do. And importantly, going back to the point I mentioned a moment ago, to make sure that you're also looking to meet the FCA's obligations to demonstrate that all reasonable steps have been taken. So consider having a formal conflicts of interest policy in place, setting out how the firm proposes to identify, manage, and also reduce any identified conflicts. Have some clear guidance in place for staff on how to recognise a potential conflict and where to escalate it to if one arises. Keep a clear record of conflicts as well as potential conflict situations. Review your policies, your conflict policies, on a regular basis. And always keep in mind that the duty of care owed to the policyholder is to act as its agent and the obligation to act in their best interests all the time. And it can be seen from the points I've just described that what sits at the very heart of this is really communication. It's communication within your organisation about conflicts and how they might arise. And it's about making people stop and think and consider if there's a conflict and then how best to manage it. Now, none of this is easy. And to properly manage risk, it's clear that those organisations that operate on a strong collaborative culture with no blame are the ones that are likely to do best. But it happens. So what do you do when a conflict arises? Well, conflicts can arise in many forms, and a prescriptive approach really cannot be dictated in terms of how you manage them. But really, the first thing to consider is the nature of the conflict and who or which parties could be disadvantaged by a certain course of action, a business decision, a placement or acceptance of a risk. Now, if the conflicts of interest can be avoided, then clearly that's the preferred option if there's an alternative course you can take. However, that's not always going to be possible. And where the potential conflict can't be avoided, you really have to consider whether it can be managed in order to make sure that at best it's mitigated to the best extent possible. Now, dealing with conflict, brokers again must have regard to the provisions of the ICOBs. And some of the key requirements for the brokers that arise there is that brokers must provide clear, fair, not misleading communication to customers. Brokers must act honestly, fairly, and professionally in accordance with the best interests of their customer. And crucially, brokers must disclose and manage any conflict of interest adequately. Now, it seems to me perhaps that those rules around conflict perhaps initially came in when people were thinking about commission and fees and how those were all to be managed way back when. But of course, if you think about it, it goes very much to the core of any dispute that may arise and the obligation in terms of making sure that your client is not disadvantaged by the course of action that you're taking. And it goes without saying that there is no one-size-fits-all solution as to which course of action to take. In reality, it's all about balancing the commercial relationships with the legal and regulatory issues that arise. Now, to try and put things in context and to give a couple of examples, what we're going to do next is just look at a couple of common questions that arise, such as when an insurer takes a point to decline a claim for reasons that that could be the broker's fault, at what point does that broker stop acting? Can they assist, for example, with a complaint to false? And also just a word further on to the fiduciary duties that I've mentioned, because these do sit quite closely to the core of the duty that is owed. So on that note, I'm now going to hand over to my colleague Andrea, who will pick things up from there.
Thanks, Neil. So taking the first question, what happens when the insurer takes a point or declines a claim for a reason that could be the broker's fault? For example, a broker who makes representations about the all-embracing nature of policy that insurance subsequently challenge. As agent of the policyholder, the broker owes duties to assist the policyholder with any claims in relation to the policy. But the question the broker must ask itself is whether they can truly offer independent advice in such a situation. Now, there is a conflict here. The broker is the policyholder's agent and represents its interests. They must have in mind the requirements imposed by the statute and the FCA, as well as observing the duties owed to the policyholder in contract, in tort, as well as fiduciary duties. If the broker has made a mistake which potentially compromises these duties, they should inform the policyholder of the conflict as soon as possible, and if necessary, advise the policyholder to take independent legal advice. The broker should consider whether they can act and keep this under regular review. Otherwise, they could face a claim from the policyholder for breach of duty, breach of contract, negligence, and/or be in breach of the FCA requirements and rules. That's not to say, however, that in all cases the broker should cease to act. Of course, in many situations, the best person to assist the policyholder in relation to getting the claim paid is in fact the broker. So this leads to the second question that Neil posed: at what point should the broker cease acting? Again, there's no one-size-fits-all answer to this question. It depends on the circumstances, but if the broker is unable to act in the best interest of the policyholder, they should cease to act immediately. So when a complaint or dispute cannot be resolved, it will often be referred to the Financial Ombudsman. If this happens, can the broker assist with the complaint to the Financial Ombudsman? Technically, yes, they can, but this may give rise to a breach, and the broker must ask themselves whether it is really able to fight the insurer with the vigour that's required. Also, as we'll see in a moment, when we discuss the case of Daland, what happens if there is more than one reason that the insurer can decline cover, not all of which are linked to the broker? There's a real risk of a conflict in this situation, which would need to be properly reported, disclosed, and dealt with under the firm's policy. So as Neil mentioned before, the broker owes fiduciary duties. These sit across all of the broker's duties and represent a relationship of trust and confidence between two or more parties. They apply in all actions the broker takes when there may be a danger of the interest of one party being preferred, but they're especially key when it comes to handling money. So let's consider, for example, the duty owed by a placing broker in relation to the collection and transmission of settlement monies. The broker acts as the agent of the policyholder with their relationship based on agency law, and a fiduciary duty arises between the broker and the policyholder. There's a situation of trust and confidence between them. Should anything go wrong, for example, the settlement monies disappear, arguably there is a duty of care and negligence and also fiduciary duties. A potential of conflict of interest does arise, and the broker would need to consider carefully whether they can act. It's not always clear-cut, and you need to consider the nature of the relationship carefully to determine what duties are owed, fiduciary or otherwise, as well as what potential conflicts arise. In the recent case of Equitas and Sanday Investments in 2021, Equitas sought to recover as an assignee from insurance intermediaries at Lloyd's sums due to syndicates which had been collected by those intermediaries from reinsurers but not remitted. Equitas argued that the intermediary owed a range of obligations, contractual obligations, tortious obligations, and fiduciary duties, as well as being liable in restitution. They relied on the earlier 2013 judgment of Justice Mars in Equitas and Walsh and Brothers. However, The judge found here that the facts of the case were materially different from Walsham, and in this case, the insurance intermediary owed no such obligations. In particular, here, the insurance intermediary was not a Lloyd's broker and was not subject to the code of practice for Lloyd's brokers. It did not have a direct and continuing relationship with the relevant syndicates at any time, and its responsibilities were not as extensive as those owed by the conventional Lloyd's broker in Walsham, which extended to the administration of the policies generally. The detailed judgment discusses a number of pertinent issues, including whether a retainer between the parties could be implied and the circumstances in which broker's duties give rise to fiduciary obligations. The judge also commented on the significance of the Lloyd's Broker Code in determining whether an entity in the insurance field was or was not acting as a broker. So moving on to defending allegations of conflict. The potential defences in claims arising in these conflict situations is a broad topic, and we're going to focus today on one aspect only, which is causation. So, for example, a typical broker's negligence action where the policyholder suffers a loss for which it's not properly insured. The policyholder alleges that, but for the broker's negligence, it would have been insured and would have received a payment. The broker may be able to establish that even if he had acted with the due skill and care, that the claimant, the policyholder, would not have received the payment in any event. There are other reasons that the policy could be declined, and the chain of causation is therefore broken. This, however, gives rise to a real danger of a conflict arising. For the broker supporting a policyholder client, how hard do they push the position that it's for the other reasons that the claim was declined and not the ones that rest with their advice? Certainly, if the position arises that the policyholder's own actions equally led to the reasons for the declinature, then the broker cannot take sides and push the emphasis one way or the other. These cases are the trickiest by far to deal with in practice, and they require very careful considerations to make sure that you don't fall the wrong side of the line. So we're going to look now at the case of Deland and Butterworth Spengler Commercial in 2018. Now here, Justice Butcher made some interesting findings in relation to the approach of the courts to causation in brokers' negligence cases. In this case, the brokers were liable to pay damages to the claimant in relation to their negligent placement of a constructional risks insurance policy. The judge found that in breach of duty, the brokers had failed to ensure that certain material facts were disclosed to insurers and gave inadequate advice to the insured as to its duty of disclosure. These breaches rendered the policy voidable and justified its subsequent avoidance by insurers. The decision makes clear that in brokers' negligence cases, to establish that the negligent act caused the relevant loss, an insured is required to prove on the balance of probabilities that the negligent act or omission would have caused the insurance claim to fail. It's not enough simply to prove that their negligence impaired the insured's claim under the policy. In other words, where insurers would have been able to avoid the policy or reject the claim on grounds unrelated to the broker's negligence, the court has to determine whether the insurers would in fact have exercised their rights against the insured. So against this background, it's possible to see how the broker can get into a pickle if they don't manage the conflicts at the outset. They could be left arguing about what the true reasons are that the claim has been declined, which puts them in conflict with their client. Now, we don't know what the position was regarding the post-loss correspondence in this case, but classically, these will all start with the claim being declined and the broker then wanting to look to do all it can to assist the client. But then the matter not being resolved, the client turns its guns on the broker, such that the post-loss correspondence will then be closely examined. So by way of a brief summary, the practical points that we have discussed today in relation to conflicts: always be mindful of the duties to the policyholder, be alert to potential conflicts and have appropriate systems in place to deal with them if and when they arise, in accordance with the FCA guidelines and principles. Balance the commercial relationship with the legal and regulatory risk, and remember that one size does not fit all in these cases. Deal with each potential conflict on its own facts and seek legal advice if in doubt. That's all we've got to say for the moment, and I will now pass the baton on to my colleague Harriet to deal with any questions that you may have.
Thank you very much indeed, Andrea. Well, we do have a couple of questions, and these will be directed, if I may, to you, Neil.
Okay.
I'm sure you're still there. Thank you very much. Speaking as a broker, one questioner asks, if I have the sort of situation you describe where an insurer has declined a claim that I think might be down to a failing on our part as brokers, when do I tell my insurers, my own insurers, and how do I manage the client?
Yeah, it's difficult, isn't it? I mean, when you say my own insurers, I presume by that the question means the professional indemnity, your own professional indemnity.
Yes.
Insurers. It's difficult, isn't it? Because of course, there's no claim against you at this point. It's only a circumstance. But as the broker, you're going to want to make sure that if you do end up facing a claim at a later date, your policy has been triggered and you've got that protection in place. You're a broker, of course, as well, and so there's no real. We often do these lectures, and the person who should know how the policy operates the best is the broker. So I would certainly err on the side of caution when it comes to notifying potential circumstances. Of course, your policies may vary in terms of whether it's incidences that may give rise, that are likely to give rise, etc., to a claim. But I would err on the side of caution. But then I'm a lawyer, and so I'm going to be naturally cautious, I think. You can't notify absolutely everything, and I think probably what you need to do is to do an investigation into the background of it, because some things are going to be clear and some things aren't. So if there's been a failure to put a BI cover in place and there just simply isn't any BI, well, that's quite straightforward. There's no cover, you're likely to be facing a claim. Things get a little bit grayer if there are some multiple reasons for the declinature, which maybe some have more potency than others. You get into that common dispute you've got where you told the client something, or you had the discussion with the client, you're sure you had the discussion with the client, but unfortunately there's no evidence on it. And that sort of shade of grey, then you start to question, well, what's the size of the claim that's been brought? If it's a couple of £1,000s, it's less likely the client's going to push the button on it. If it's significant value, then yes, it's more likely to lead to a claim. So I'm afraid there's no really easy answer in terms of a black and white yes or no. But I think it's knowing what the obligation you have under your professional indemnity policy, and then B, just having to take a view on it. But of course, taking the client with you on that thought process.
How do I do that though?
Well, I suppose that's the difficulty, isn't it, in terms of how to manage your client. I'm well aware that clients are, what's the analogy? Clients are hard won and easily lost, and a lot of effort's been put into renewal, into winning clients in the first place. But I think there is a way of managing a conversation with a client that can keep the client on board, that doesn't put you on the wrong side of the conflict line. It's about being open with the client. It's about being honest with the client if something obviously has been missed. If it's one of those cases where there are multiple reasons to avoid a claim, some of which may or may not drop to the broker, some which clearly drop with the client, I think you have to look at your phraseology that you use in correspondence with the client and with FOS, etc., and how you put a claim across. If you have reviewed the file though and you think, hang on a minute, I'm in this, there's clearly no evidence, then I think really you need to be saying there's a conflict arising here and we need to step back. And in those circumstances, if you do need to do that, now it's not something that Mills and Reeve would do, but there are, and I'm sure on the Zoom today, people will know of these sorts of firms. There are some firms out there who are very prepared to act for clients, for insureds against the insurer, and who have a motto that effectively says they will never pursue the broker. And so perhaps the best thing you can do when managing the situation is refer them on to the right person to help them get it sorted. But whatever. But what you mustn't do is get into that correspondence. Sorry, Gary, it's a plea from having defended many brokers' negligence cases, that the worst thing that can happen is that you've got into a round of correspondence with the insurer where you start to dismiss as fanciful points taken by the insurer declining a claim, And in fact, that could be your best defence, because that's your non-negligent act. So be very careful with the correspondence you write. Sorry, I slightly long answer, but I think that's sort of, hopefully that wraps gives the response.
No, absolutely. I'm very conscious of time just for the moment, but very briefly, if you can, as a broker, when do I have to tell the client there's a conflict, and what do I say? You've got literally a minute, Neil.
Yeah, well, I think I'd probably say I refer to my earlier answer. I think I keep on saying there's no hard and fast rules. There isn't. You must just reflect again. Discuss it internally. Don't make decisions on your own. I think the worst thing you can do is your key client. You don't want to lose that client.
Yeah.
But you start making decisions in haste. So I think you've just got to reflect, discuss internally, use the people around you to bounce things off. But don't leave it to the last minute, because if you put it off, before you know it, the die is cast, and you really will have upset the client by then.
Thank you for that, Neil. I'll pass the baton back to you to close up, if I may, as we're running out of time right now. Thanks.
Yes, great. Thank you, and thank you everybody for joining us just for the half hour. Hopefully you found it informative. Hopefully you're not too frustrated that you're walking away without any hard and fast answers. The issue of conflicts is, like I say, is one that's not just arises for brokers, it arises for all professionals, and it's increasingly one, I think, that we're all being more and more having looking over our shoulder and making sure that they're managed properly. Our regulating bodies are very, very keen, quite rightly, to ensure they're managed properly. So hopefully it's left you with some food for thought, and let me leave you with one last nugget of food for thought, and that is on the 11th of May, my colleagues Ben Hardiman and Ian Tassel are going to be doing the next session in the box, which, as you know, is our series of webinars of interest for insurance intermediaries and those working in that sector. And on the 11th of May, Ben and Ian are going to be dealing with the topic of apportioning liability and responsibility between retail and wholesale brokers. So again, quite an interesting topic that can arise in all sorts of areas. So hopefully you can join us then, and thank you again for your time. Hopefully you can get outside and enjoy some sun at some point during the course of the day. So thank you again.